The 4 are expected to be female, likely 1 civilian and 3 members of the Israeli armed forces. They'll be set free in exchange for the release of as many as 180 Palestinian prisoners. Hamas is also due to give more details on the 30 other hostages they've agreed to return home in Phase 1 of the ceasefire plan. Those details should include which of them are still alive. Jonathan Savage, Fox News.
On Wall Street, falling stock futures suggest selling the day after the S&P 500 hit a record high. At tennis's Australian Open, the first Grand Slam of the year, a dramatic exit.
Please, guys, don't boo a player when he goes out with injury.
Alexander Zverev speaking to the crowd at Rod Laver Arena in Melbourne today after Zverev advanced to his first Australian Open final as a result of 10-time champion Novak Djokovic needing to end the match early. And then the crowd booed the 24-time Grand Slam singles champ. But today a muscle tear in Djokovic's leg was too much to overcome. Alexander Zverev will face the defending champion Jannik Sinner in the championship match early Sunday morning, 3 a.m. Eastern Time. Jannik Sinner eliminated American Ben Shelton.
That's Jared Max. I'm Dave Anthony, Fox News.
Lawrence County depends on WDXE News. On the air since 1951. This is The Legend. 105.3, 95.3. WDXE.
That's us, WDXE. It's time for Stan Pierchoski. Well, Stan, we've been apart for a while, buddy. You're back.
Good
and
morning.
I'm back.
Good morning, Jeff. Yeah, it's last week you had some family issues, and
Yes.
I don't know. I think maybe the week before it was the snow. I can't remember, but we have some things, but it still went on. I think LB was in here last week, and
Yes.
worked good. He doesn't ask as many questions as you do, which is good, but which is good or bad. I mean, I like the input.
Yes.
When we talk about stuff, because when people ask questions, what I usually find when they talk about estate planning, when people ask questions, there's a ton of people out there that have the exact same question on their mind. And it can only be so many questions, right?
Right.
And it's really always falls on the same thing. And so, that's important to me because that's where the rubber meets the road. Those are the experiences they're dealing with, and that's usually they're the situations that need to be resolved. And
right.
So I love the feedback. We got a seminar tomorrow.
Oh, that's right.
It's tomorrow. It's right here at WLX in the back of the building at what you guys call the Country Cafe. I always feel need to say this. There's not a sign that says that. And so just find WLX. You can't miss that. It's
right.
And it's a big building and it extends way backward because it used to be a bowling alley. So it's kind of a big building. But don't try to come in the front door where the radio station is. It'll probably be locked because your staff on Saturdays, I think, is minimal. And the ones that are here are actually on the air and they can't come open the door. But that's not where it is anyway. And so if you just drive in the parking lot and go to the back of the parking lot, you'll see a set of double doors. You can't miss them. There's the only other door in the building, I think. And that's where it is. There's no sign. And I also want to make sure that people know it's not a real cafe. I mean, don't expect to order lunch while you're here.
Right.
But they call it that. They actually, it's a nice big venue. It's a big room, tables, chairs. Every Friday night they do picking and grinning and dancing.
They do, yeah.
And they raise the money and give it to disaster relief and
That's
stuff.
right.
So they do it's a real magnanimous thing. But it's plenty of room. And we have got a big crowd. Crowd. I just stopped and asked LB on the way in if I worry about people hearing me when it's a big crowd. Because sometimes I'll say, can everybody hear me? And everybody says, yeah. But the people that can't hear me sometimes are timid and don't want to say no.
Yeah.
Or maybe they didn't hear me say that. But I asked if with all that stuff they have there might be a PA system I bet you'll tie into. And I don't know. And I don't know if it's probably too late to figure out how to make it work.
Yeah.
So I'm probably going to have something like that. I might be able to rig it in a day's time. It's like a karaoke, so we have these, they're wireless microphones, but they're handheld, and that's what I wanted to avoid. I want to try to get a headset or a lapel mic.
Yeah.
Maybe I can make it work.
Yeah.
But I have a little receiver and an amplifier, and I got a couple of speakers that I could bring, and if I can get it to work, I'll work on it today. If I can get it to work, I'll bring that in and set it up. But nonetheless, it's a good crowd. I think we have over 50-some people attending.
Oh, wow. That's awesome.
And when we set here at this place, we set out tables and chairs, and we have round tables, right?
Yeah.
And, of course, when you make a row of round tables, you can't pack them super tight. And the thing that concerns me is, although there's plenty of room for everybody, if you're on the third or fourth row back, you're getting a ways from me and my voice. So I want to – that's what the concern is. And I think the people in my office, the girls in my office, think it's more necessary than me. I can be loud if I need to.
Yeah.
So,
well, the acoustics in that room are not bad. They're not bad at all.
They're very good. And there's lighting, there's heat. We'll have probably have coffee. We don't normally have coffee when we have those, but we probably will because it's going to be cold.
Yeah.
And we have some light refreshments. Miss Tammy makes.
There's a nice coffee machine back there, as a matter of fact.
Yeah, we got a gentleman that has come to this seminar, I think at least 4 times, and he openly admits to the girls that he comes because of Miss Tammy's muffins.
Well, maybe I need to show up to that.
I'll save you one. If you don't make it, I'll keep one for you.
Yes.
But we'll have some light refreshments there, and I think we'll probably have some coffee because it is going to be kind of chilly in the morning. Not too bad later on, but we'll be out of that bitter cold, thank goodness. But anyway, that's tomorrow, and it's right here at the WLX radio station. If you're listening to me and you're a little farther away than that, the physical address that you can put into your GPS phone is 1212 North Locust Avenue, Lawrenceburg, Tennessee. And that'll bring you right here.
That's right.
If you don't have a GPS, here's what I tell people. When you get into Lawrenceburg, if you look around, you will see a tower. It's the tallest one in the county. It's like 350 feet tall. It's a big one. And it's like a rainbow. If you come to where that tower hits the ground, right there's a set of double doors. Come on in, you found the right place. So that's a pretty good navigational tool.
Not hard to find at all.
But it's called Wills, Trust, in the Nursing Home, and that's what we talk about. We're going to discuss Last Will and Testament, what it is, what it does. We're going to trust, what they are, what they do, problems they solve. Then we're going to shift gears and get into long-term care, where we talk about my asset protection trust. We do talk a little bit about crisis planning, but we really only scratch the surface of that because I'm kind of working on another seminar. I could spend another hour or two just on crisis planning.
Yeah.
So we discussed the fact that there are options. We go over them very quickly, that sort of thing. But that's the gist of the seminar.
Right.
And it starts right at 10 o'clock. Or, if it's right at 10 and I see a couple cars parking in the lot, I'll wait a minute or two. But nonetheless, we try to start as soon as we can at 10. And it goes for about an hour to 10 minutes, maybe an hour and 15 minutes. It just depends on how sidetracked I get.
Yes.
But it's and I want to tell you, it's nonstop action from the minute I start to the minute I end. So if you're thinking, well, it's just one of those things where I go and they're going to give us some food and maybe a free meal and they're going to get us to sign up for something. Okay, it's not that at all. I'm not hoodooing you, I promise. I mean, this is I call it a free educational seminar. I focus on the word education more than free. But
yes.
Years ago, I have come to the conclusion that folks, when it comes to estate planning, are not aware of the different options they have.
Yeah.
And if you're not aware, you're not aware. And you can't find the answers to it on the internet because they're not there.
Right.
And so you come to it, and I talk about these options. And listen, if you think I'm going to lock the door and not let you out until you sign something, all I can do is give you my heartfelt sincerity that is not the case.
Right.
If you want to get out in the middle of it and leave because you don't like what we're talking about, I mean, feel free to. Grab a muffin, take with you.
Yeah.
No problem. No hurt feelings, no hard feelings at all. It may, a lot of people like what we have to talk about. A lot of people engage, but it's certainly not for everyone.
Sure.
So no problem. That's what we're trying to find out.
Right.
If you listen to what I have to say and you say, that's just not for me or my family, then you have made an informed decision.
Right.
And that's the good one. That's a good decision because of the way you made it.
Right.
We stay busy enough. It's not a problem. And but there's no pressure whatsoever. Won't make you sign anything. Won't make you commit to anything. We offer certain incentives if somebody wants to go because
yes.
And that the incentives I offer, I do it for a very specific purpose, and that is like one of the things we offer if you come to the seminar, we offer a different price. And I also offer if you want to come and sit and talk to me, a 2-hour meeting. We call them family vision meetings, and we can sit and talk about that. That's where we kind of do a deep dive into what you're concerned about. Okay. Now, I offer that at no cost, that time, that 2 hours, and the incentive in the price. And here's why I do it. If you go to the time, energy, and effort to pre-educate yourself by coming to a seminar.
Right.
Now, I have a recorded version. I even do that for folks when that's something we created during COVID was what they call an evergreen recording that's kind of void of any dates and stuff. But nonetheless, but if you come to a seminar and you learn the basics, like the difference between a will and a trust, and a couple of the options on the asset protection trust, and you kind of learn the basics. What happens is if you decide to come to one of those meetings, those family vision meetings, you will have already started to kind of lean in one direction as to what got your attention during the seminar. You know what I mean? Like you're already starting to think, I'm thinking the revocable living trust, or I'm thinking the asset protection trust, or I'm thinking a will plan, or whatever. And so when we have that meeting, we hit the ground running. It's so much more productive. here's the thing I'm trying to avoid. And if you have to pay for my time if you do this. If you come in off the street cold, and you sit down and it's like, okay, tell me what's the difference between a will and a trust? If I'm going to spend my time talking to you about that, then the girls will make you pay for my time. Okay, but if you come to the seminar and we get past all those fundamentals and the easy stuff,
right,
and then we spend that 2 hour, and it usually takes 2 hours. We spend those 2 hour meetings deep diving into your family, the concerns, problems you're trying to solve. It's okay. I got this. I want to leave this. I have this property I want to leave, and I got a child that's kind of got a problem, and I want to make sure he's protected a certain way. Get into those details and stuff, and so it's a much more productive meeting if you've attended the seminar or watched one ahead of time, because you already are pre-educated, I call it. And so I reward that because it's better for you, it's better for me, because that time is important. That's an important time to spend, and we don't want to spend it talking about fundamentals.
No.
We go over the fundamentals in the seminar.
Right.
And another thing is, if you come to the seminar, you will learn enough that when you leave it, you'll be truly able to say to yourself whether you think it's something you want to look into further, or you just say, that's just not for me. You will have enough information to at least make that decision.
Right.
And that's good. And again, I'm not here to talk you into anything. I'm not here to talk you out of anything. If you think it's not for you, then that's the right decision for you.
Absolutely.
Which unfortunately I have trouble overcoming this whole concept because of the industry of being an attorney. Some people, even though I just said that, some people say, "Well, I just don't believe that." No, I had a guy call me one time. Well, I just, while I'm on this subject, had a seminar a couple of years ago.
Yeah.
And guy called and RSVP'd. I don't remember if I took the call, the girls took it. But then a couple of days later, a week later, somebody else called and specifically asked to speak to me.
Right.
And so they let the call through, and I spoke to the gal, and she said, "I'm calling on behalf of my boss. My boss signed up for your seminar." I don't even remember any specifics, but she said, "She signed up for a seminar," and now he's starting to get a little reluctant because he told me to call and ask. He says he's worried he's going to have to commit to something. And he said, and she goes, basically he said to me, no attorney is going to give up 2 hours of his time and not want something for it. And so, maybe other attorneys think I'm doing the wrong thing or something. I don't really see any harm with what I do. And I told him, I said, it's not like that. Just like I'm telling you now, and the audience that's listening now, it's not like that. We talk about it. I do most of the talking, of course, and then we have question and answers at the end and stuff.
Right.
But, and I tell people that if you wanted to set something up, half my staff is there anyway. You can talk to them and get on the calendar, because after these seminars, I do get kind of busy, So if you want to sign up, but if, it's not, and it's not like this clock goes up on the wall and says, if you sign up in the next 10 minutes, you will get extra, it'll be free or something.
No pressure.
I've had people come to me and said, I went to your seminar 2 years ago, and now I'm ready to go forward. And I still extend those incentives of the price cut or the free vision meeting and stuff like that. I still do. No, I don't do business that way. That high pressure sale is a bunch of bull. If you buy now, you get it cheaper.
Yeah.
Tomorrow you get full price.
Yeah.
If something's worth what it's worth, how can it be worth half today and not half tomorrow? It's just I don't do it. But that was a good example, and I remember that gentleman showed up, and he was still a little reluctant. And I'm trying to put him at ease, and I said, look, I'll tell you what, we'll even feed you. We'll have some food there for you.
Yep.
So maybe you can do.
Had that happen to me just yesterday with a sales call, and I'm actually considering using the services, but they're like, but if you'll do it before the end of January, we'll give you this discount, blah blah blah. So and I'm like, look, the discount is okay, and I'm great to have it, but I'm trying to make a decision based on what I want to do. Mm-hmm. Yeah.
Not make it now and be done with it.
Right.
But I haven't had a chance to think it out.
Right.
Perfect example of what we do. If you're trying to think of what you can do, if you don't know what you should do or can do, it's because you don't know the options. Right. Come and learn about them. Take your time. I'm telling you, that's an absolute true statement. Many people have called me, been here about a year ago, 2 years. Actually, I think there's one as long as 3 years ago. And now a lot of times, what those people will say? They'll say, hey, I came to your seminar 2 years ago, and we want to do that asset protection trust, and man, I just wish we'd have done it then, because we'd be 2 years into that 5 years you talk about. But we just didn't. We thought about it. We talked about it. We thought about it. We talked about it. And now 2 years later, we decided to do it. So I get a lot of that. But it's no problem. I offer these incentives. They do not expire. You don't even have to prove to me you came to the seminar. Just tell me you came to the seminar.
Yeah.
And because when I start talking to you, I can tell if you came or not. I'll know right away just by talking to you whether you had attended or not.
Right.
Sometimes we send a recorded version, and I don't know why people say, yeah, I watched it. Okay. And I mean, you don't have to tell something to me that just to convince me or something, but I'll know right away, and I'll say, it doesn't sound like you watched it because I talked about this, this, and this. And,
Right.
But I don't require it, but it's for your benefit. It would behoove you to attend the seminar before having that meeting. Because man, that meeting can be very productive. If you walk in and say, you know what, I saw your seminar stand, and I'm worried about long-term care, and I think that asset protection is something I'm really interested in. Okay, well, what do we start talking about? I don't start talking about what I talked about at the seminar. Now we dig into the asset protection trust, what it does, what you need to know and understand. We hit the ground running because we already know the direction we're going,
and you know the right questions to ask to get to where you need to be.
But if you're worried, it's going to be some underhanded thing to make you commit to something you don't want to do. Yeah, hey, if you're not 100% in and want to do this, then I don't want to do it for you because I just don't. I couldn't live with that. I want you. This product, when you know what it does, most people are interested and they're happy with it, and I agree. I've had the product myself. It is a grand thing. The planning really makes you feel good when you get it done. A lot of people claim a real weight off their shoulders when they do this kind of planning. So I don't have to sell it. I don't have to talk you into it. I mean, I don't have to. You either want it or you don't. And if you do, that's what we do, and we'll be glad to help, and we would like that you use us, but. If you don't want to do it, then that's okay. I mean, we'll still part friends.
Yeah, absolutely, absolutely.
And I got some people that just are perpetual, not make up your mind. I mean, I have people that probably came to a seminar 5 years ago and still call me and ask a question and a question and a question. I just know someday they'll pull the trigger.
Well, for some of us, and I fit the category. We are professional procrastinators.
Yep. And that usually comes from a lack of insight or lack of knowledge. Because if you knew everything about it, there's nothing to procrastinate about.
Right, I agree.
Or risk or something, or what you're worried about.
Well, Teresa and I, just this week, as a matter of fact, because we've dealt with the passing of her father, which you helped us with in his stay in the nursing home and all those kind of things.
Again, I'm sorry to hear of his passing.
Thank you. But she and I just had this conversation. We need to review our own personal belongings, circumstances, our trust, those kind of things. And I said, well, I need to pile up all my stuff and take it to Stan and let him review it and figure out what we need to do next.
Well, I don't even have to see all that stuff. We have a workbook that you fill out, and we'll talk about it because, when you have a trust, you put property into it. I don't need to see what all the property is, but what I need to know is the kind of assets you do have.
Right.
And I don't even in our deep meetings, our family vision meetings, I don't get real nosy and say how much money's in the bank account.
Yeah.
If you tell me I have a checking account, I have a savings account, and I have Edward Jones or Morgan Stanley investment account or something like that. What's important to me is the type of asset that you have. And when you tell me that, I can say, well, here's what we want to put in the trust. Here's what we might not want to put in the trust, depending on what we're talking about. Because on our revocable living trust, you want to put everything in there. But if you're doing the asset protection trust, we don't put everything in there because of the way it works. But there's certainly a selection process as the best candidates to put in there.
Yeah.
And so we'll talk about it that way, not necessarily hey, give me a listing of how much money I have in the bank. And
you may not want to get into this, but you might, just because the way you just said that. How would you determine what would go into an asset protection versus a revocable?
Yeah. Well, okay, I will talk about it. Before I do that,
okay,
I talked to you about something when I first came in, and we last week when LB was here, we went the whole show and never gave the phone number because neither of us thought of it. But it's a call-in show. Now,
that's right.
I also want to let you know that you had a caller before. I was listening to the show on my way over,
right?
And there seemed to be she mentioned some concerns about recording the show, and I know you said, hey, this show's not recorded, but Mr. Pierchoski's show, Bulletproof Stamp Plant, we do record. Now, we record that for a couple of reasons. One, I think it's what we call visual radio. You can see us on Facebook.
Right.
And they record it somewhere where people can look at or listen to past episodes, right?
Right.
We also record it because, when we had Snowmageddon a little while ago, you guys like to have some recorded versions that you can play in absentia, right? Because nobody was here.
So, right.
So the show can go on, but it's a show that was recorded.
Pre-recorded.
I don't keep too many pre-recorded ahead of time. I think we maybe did that once, but anyway, so we do that. But if that concerns you, because it sounded like it concerned the caller, if that's a concern of yours, and this is a call-in show, by all means, feel free to make your call anonymous, hypothetical. Don't mention names. Just give me the circumstances, and we'll still nuke it out.
Sure.
And then if you want to talk about it, the real detail, you can call me or schedule something with me that's not on a public forum like this.
Right. So, and that phone number is 931-766-9393 if you'd like to participate in the program this morning.
So the question was, when you have a trust, you have to fund a trust. Funding a trust is moving your property from not in the trust to in the trust.
Yes.
So when we have a revocable living trust, that's a trust where you complete probate avoidance. All trusts avoid probate. So a couple of its big advantages are you can avoid probate. Right. 2, you can really control the property on how it goes to your heirs if there's a need to control it. But there's several advantages to it. I talk about those in the seminar. But when it comes to funding a revocable living trust, we want to put everything we own into it. Because if it's not in the trust, it's not in the trust. And if it's not in the trust, it could go through probate all by itself. Now, we do have a couple of safeguards in the whole plan to make that as easy as possible. But Plan A is put everything in the trust. So your checking account that you use every day, put in the trust. Savings account that you may not use very often, put in the trust. Your investment accounts, brokerage accounts, CDs, you name it. If it's a financial institution in posture, it belongs in the trust.
Right.
Now the difference comes up when we talk about the asset protection trust, the one that protects our property from long-term care or creditors. It's just that long-term care is the creditor everybody's worried about. Okay. Now, when you have an asset protection trust, we have to give and take a little bit. We have to give some, in order to get creditor protection, we've got to give something up. And what we've got to give up is the access to the principal of the asset.
Okay.
Now, we can still get at the principal, but we have to do it a special way. Now, I'm probably not making much sense because there's so much more to what I'm leading up to, to understand it. But the bottom line is we don't put everything we own into an asset protection trust because of this concept of we don't have access to the principal. Now, we have control of the property, but no access to the principal.
Okay.
And there's a reason for that. I mean, it's a legal reason, but that's the way it needs to be. So what we don't put in an asset protection trust are things that are changing all the time, or that here's the way I say, do not put into the asset protection trust something that you contemplate you will need to live off of.
Right.
So let's take your checking account. You're right, you're paying the light bill every month, you're paying the rent, you're paying going to grocery shopping. I mean, you're constantly using that thing.
Right.
That is not a good candidate to put into the trust because we can get money that's in the trust or properties in the trust. We just have to do it a special way.
Yeah.
And it's cumbersome to do that when you want $100 to go to Walmart and get groceries Friday night or something like that,
Right.
So we don't. We keep it out. We protect it from probate a different way, at death and stuff like that. What we want to put in the asset protection trust, is like in your business, the big ticket items like the real property.
Yeah.
Maybe if you have an investment account that you're not really living off of, or it's just making interest, and you're just using that. Because it's called an income-only trust, meaning income's okay to come out of it, but it's the principal that we're kind of restricting our ability to get at.
Okay.
And that's what gives us the creditor protection. Because if you can get at it, your creditors can get at it. You know what I mean? So we kind of create a situation where we limit our getting at it so that they can't get at it. And that's the whole concept of it in simplistic terms. But so if there's something, if you have these CDs that you just keep rolling over and you think, I'm just going to give these to the kids eventually, I'm just keep rolling over and rolling over. I don't need them to live off of. That's a candidate to put in there, or some kind of, but we want to get these big ticket items, definitely the real estate. And it's very, very common in this neck of the woods that the trusts that we do, probably the majority of the asset protection trusts we do, the only thing that is put in it is the real estate. The house, the farm, stuff like that, not really money in the bank. But if you have money in the bank that would qualify to be in there, let's put it in there. And we're contemplating never needing it. But the good news is with that asset protection trust, if we ever do need it, say circumstances change and we need it, there's a way to get at it.
Yeah.
And when you get at it, the trick is it's not really access. Access is a specific legal term on how you can get to something. This is not access. It's really the exercise of a trust retained right that you can exercise. And therein lies the difference between the two. So you can, and I talk about this in a seminar, there's a way to get at this property. But I like to structure them as if we are contemplating not getting at it. But it's good to know that if our circumstances change and we absolutely have to, we have a vehicle to do so. And it works very well.
Interesting.
So that's kind of generalized answer to the question. To get into the specifics, I think should probably wait till I start going through the Asset Protection Trust again on this show in a little more detail, because as I lead up to that, then it makes a little more sense. I talk about it at the seminar, but again, it's in an hour to an hour and 15 minutes. It's sort of superficial, but I put it up on and it's so much easier with I have the TV and I got a PowerPoint, and I can show the diagram of property that goes into the trust, how going out, how it comes out, like I do in my office with a whiteboard. That visual helps understand that trust a lot.
Perfect.
So there, you're right. That was a good catch. There is difference between the two. So those kind of trusts, we don't put everything into it because we can make ourselves insolvent if we can't get anything in there.
Yeah. Yeah.
But if you're in a nursing home and they say, hey, you got $100,000 in this bank account, the bank account's in this trust, they say, you can pay us with that.
Yes.
And you say, well, I can't pay you with that. I can't get at it. I don't have the authority to access the principal of it. The trust is written that way. And it needs to be written that way, because the law says if you have any access to principal, then your creditors have access to all of it.
Right.
If you have any, you have access. If you have access to a little bit of it, you have access to all of it.
Right.
And so, and again, this concept that I tell people to memorize: if you can get access to an asset, so too can your creditors.
I think that probably scares people a little bit.
It does.
To think that you don't have access to whatever you put in that irrevocable asset protection trust.
But if you come to the seminar and watch it, you'll find out it's really not bad at all. It's not hard to live with at all.
Yeah.
I mean, it is something we have to live with. Right. So I say there's two hoops we got to jump through, but when you hear what they are, it's really not that bad.
And the reason, we've talked about this, but the reason you would consider an asset protection trust is the possibility that you may end up in long-term care.
And it's expensive.
And it's expensive. And for a lot of folks who have experienced this, and I've run into them myself in my line of work, that the long-term care, it has to be paid for, and we're not beating the homes up for doing that. They have to make it work. But it can eat up all of your assets or all of your inheritances that you've built. There's a way to protect that. So that's what this is about.
It is. And I want to go over a specific thing that you probably deal with or have seen, and that is, a lot of times people that are in care or the family of somebody that's in care, they go online, they search information about long-term care. They talk to people in the facility where mom or dad's at. They talk to their neighbors. And what they'll hear a lot is, oh, don't worry, your home is protected. And now in the statute, it refers to real estate as the primary residence or other real estate. And there's only two categories, those two. The primary residence, of course, is what it sounds like. It's your home. Now, just because you're living in a nursing home doesn't mean that's not your primary residence anymore. If you're living at your house, and you go in the nursing home, it's still your primary residence. Now, if you have a lot across town, that's other real estate. Now, interesting enough, primary residence is the property that where the footprint or the meets and bounds description has your house and any contiguous property. So if you have a 5-acre lot and you got a house on it, and you somewhere along the line in your life, the guy beside you has 500 acres and it was up for sale and it was a good price and you bought it, and they share a boundary line, you now have a 505-acre primary residence. Contiguous means boundaries touching, right? But I think the statute said if there is a property owner in between you and your next piece of property, not contiguous, that falls in the category of other real estate. And those two pieces of real estate are treated differently, under the rules. Now, the primary residence, here's what I can't tell you how many times people have come to me that have people in care, and either the assisted living facility or the nursing home or whoever comes right out and tells them, don't worry about your home, it's protected. Don't worry about the house, it's protected. Now, I'm going to spend a few minutes on what that means and what it doesn't mean, because it's misleading. It's very misleading. It's like borderline wrong. If you didn't use the word protected, it might have a little more merit. Now, here's the way they treat the primary residence. Now, I know you've seen this in your practice where you have a house to sell. Let's say you're selling a house. You do auctions and stuff like that. And you find out that TennCare's got a lien on that house. And so when you sell this house for $200,000 and they have a $100,000 lien on it, when you get $100,000 of that money, has to go to them first, and then whoever is selling the house gets the other $100,000. I mean, it doesn't affect the buyer. But now they've lost half the house, the heirs, right?
Now,
exactly. How the heck did that happen? Okay, that's what I want to talk about. The primary residence is not a protected asset. Let's use legal terms. It's an excluded asset.
Yes.
And what that means is this. Let's take a couple.
Yes.
Okay. John and Jane Doe. And we'll pick on the husband. Husband's in care.
Yes.
And he wants to file a 10-care application. They said, don't worry about your house. It's excluded. So we don't. We put down all the other stuff. And we put down, they ask, where's your home? And here's my home. And so 10-care will not consider the value of it because it is a countable asset.
Right.
Your home is a countable asset. And remember I said countable means available for the cost of care.
Right.
Like money in the bank.
Right.
But they will exclude that particular countable asset. It never changes posture from countable to uncountable. It's always countable. But they're going to exclude it. Meaning they're going to take let's just say it's a nice, easy number to figure in our head, $100,000.
Yes.
Which is probably a Tobacco Road tar paper shack.
Right.
But it's an easy number, right?
Easy
For radio.
Yeah.
So $100,000 is the value of the primary residence. They're going to take the $100,000 out of your countable assets column.
Right.
Because if you try to see if you're eligible, you can only have so many countable assets.
Right.
Now, if they include the primary residence and it's $100,000, and it's a countable asset, how are you ever going to be eligible? Because you're over-resourced. Because so what they'll do for the primary residence is they will take it out and exclude it.
Right.
Now we put it in the excluded column. Doesn't mean it went away anywhere. It just means we changed. We're not using it during the eligibility calculations.
Right.
Now let's say because when you treat that excluded asset that way, now you're eligible.
Yes.
And so 10-care says, great, you're eligible. Your income goes to the cost of care. We'll pick up the tab. So it's $10,000 a month. Your income's $2,000. 10-care will pick up the other $8,000.
Right.
Okay, for as long as you're in the nursing home.
Right.
And they will. Now, you pass away.
Yes.
Okay, everybody does. That's a when, not an if.
Yes.
So you pass away. Now, 10-care is now going to impose the estate recovery rule, the 10-care Estate Recovery Act.
Yep.
And that says anything in your estate they can go after to get reimbursed for the cost of care during your life. Did you know that when 10-care pays for your services and pays your bill, and you think, oh man, we got Aunt Gertrude eligible, we're home free now, 10-care's going to pay. Did you know that after you die, they want paid back?
Yeah.
Like a freaking loan.
Yes.
I'm trying to keep my blood from boiling. Okay.
Yeah.
But they want paid back. It's called the 10-care Estate Recovery Act.
Yeah.
And so they're allowed to go after whatever's in your estate. Now think about this. Remember the house?
Yeah.
It's still there. You still own it.
Yep.
They just didn't use it against you for eligibility purposes.
Right.
But now it's in your estate, and the Estate Recovery Act says they go after whatever's in your estate.
Yeah.
So they will look and see, well, we have this $100,000 house. We paid $50,000 on behalf of John Doe, which are low numbers, and so we have a claim of $50,000, and they slap it on the house.
Yep.
Now, if you have a will that says, hey, I leave my house to my kids, you can do that.
Yep.
But that lien goes with it. And
Right.
it's a priority lien because of the state of Tennessee.
Yeah.
Now, I know you've seen in real estate that lien's on there. That's how it got there.
That's how it got there.
And so, and if you don't do it, they can force the sale of that.
Yep.
And I've seen that happen. And when they force the sale of it, they got a $50,000 lien. By the time they hire somebody to put it up, advertise it, and then auction it, and do all that, you're at the $50,000. Then the costs are another $20,000 because 10-care doesn't come down here and auction it off. You know what I mean?
No.
They're not in the business of having houses and piling them up over here in the corner somewhere. They just want the money, right?
Right.
And so it can get pretty expensive, and that's how they get at the house. So the house is not protected at all. That word just does not apply. It's more like a deferred asset.
So in simple terms, and the way I've seen it work is I'm dealing with the family, dealing with their estate, their parents or grandparents or whatever. We're selling their real estate. But there's a 10-care lien, and that's found out. They have to, you have to actually notify the state that, hey, we're selling it, and then they let you know if there's a 10-care lien.
Absolutely.
So you got a piece of property in your example that's worth $100, but they owe $50. So those that were the inheritors are going to get what's left.
Yep,
instead of the whole thing. And that's the dilemma.
It sort of works exactly as if the person passed away and still had a mortgage due.
Yeah,
and their equity was $50,000, and they
Right.
still owed $50,000.
Right.
I mean, the bank gets paid back first. They got the priority lien, right?
Right.
Now, even if there was a mortgage, the new priority lien, the new boy on the block, is the state of Tennessee. By law, their lien takes precedent over anything else, with the exception of maybe IRS.
Now, I've heard it argued, and this gets a little bit political, okay?
Yeah.
but
No.
I've heard it argued from a liberal point of view that that's perfectly well and good and right. That the estate ought to reimburse, or the estate ought to reimburse the state for what they paid. And they try to justify it by saying, well, yeah, but the state's already paid for you while you couldn't pay it, and now that you're selling your property, now you can pay it and you should pay it back. And until I talked to you, I did not realize that we were already paying for that during our lifetime and during our work life. And so they're doubling up. Can you kind of parse that out?
Sure. I get that question sometimes, and people say, I pay my bills. I always pay my bills.
Yeah.
And if I go into the nursing home, I think I have an obligation to pay my bill.
Right.
I mean, I get that, and I'm all for that. I think that's magnanimous in somebody. And I'm the same way. I don't have outstanding.
Absolutely.
I don't have outstanding bills.
Right.
I pay them.
Right.
If I ever don't pay a bill, it's because I forgot about it, and then somewhere I get reminded of it. But
Yeah.
I'm that way too. But when someone says, I'm going to pay them because I have this bill, I think we got to ask a question before we do that. And the question is, do we owe it?
Yes. Do
Do we owe it? Now, this is not political, but it's very legal. You know what
Yes.
I mean, our courts have analyzed TennCare and the Medicaid, and the federal courts Medicaid from the day it came out in July 30th, 1965, right? I mean,
Yeah.
they've thrashed over this decades ago. And in a nutshell, the ruling is this. It is a program that you participate in, and you participate in it involuntarily, which means if you got a letter from TennCare or Medicaid someday that said, hey, is it okay if we deduct money from your check every month or every week towards medical services and stuff like that, do you mind? I mean, you didn't get it because they didn't do it.
Yeah.
They imposed the law, imposed it on us, and we are participating involuntarily.
Right.
But we are participating. So
Right.
don't lose sight of that fact. Now, the courts have said if you participate in a program involuntarily, then what that program does for you, or those benefits, rise to the level of an entitlement.
Okay.
Not a right, not even as high as a privilege, but it's an entitlement. So when people tell me welfare, I mean, TennCare is welfare. It's not. You have an absolute entitlement to it because you've been paying for it all your life. Every check you ever made, if you've been making checks all the way back to July of 1965, there's been money taken out of it for these services. And that's right, to fund this program. Now when you need it, should you have to pay for it again? Now, I'm going to back this up with strong authority here in just a minute, but that's the question I would ask. Do we owe it? We've already paid for it. I mean, we've been paying for it all our lives. Yeah. What if you pay for it all your life and you never go into a nursing home?
Right.
Do you get the money back?
Yeah. No.
Of course not. So the court said it's an entitlement, but here's what they also said: it's an entitlement. You have an absolute right to TennCare benefits. However, you still have to qualify for them, and that's the eligibility that we deal with so much.
Right.
You know what I mean? You got to have so many assets. You got to have income below a certain level. All those stuff that we deal with, the financials. Right. Okay. They said if you qualify for it, you have an absolute right to it. Now, it's not welfare because the Act itself says that if you go into long-term care, you have a duty to shift the burden to the state of Tennessee Bureau of TennCare. And the reason you have a duty to do that is because that's what the program is there and that's what it's for.
Yeah.
So when people say, well, you're trying to shift it to the state to pay the bill, we're supposed to do that by the Act itself. And that makes sense. That's the same.
Interesting. I've never heard it put that way.
That's the same in all 50 states.
Yeah.
Because you have the Medicaid thing, which is the federal act, and the states adopt certain things. All states are different because they all operate on their own.
Yeah.
But it's all under the same federal Medicaid Act, right? Maybe we talk about that 5-year rule, right? Here's a perfect example. We talk about the 5-year look-back rule.
Yeah.
That used to be 3 years. And in 2005, when they came out with the Deficit Reduction Act, and Tennessee adopted it in 2006, the states, that was in there to change it from 3 years to 5 years. Now, it was up to the states to adopt it if they wanted it or not.
Yeah.
49 of the states said, yeah, we want it, and one state did not. So, you can all be different, but you just got to be in compliance with the federal Medicaid Act. So I like to think of it this way. You got this big bubble. It's the Medicaid Act, right?
Right.
Inside this bubble are 50 little bubbles. They can float around. They can be big bubbles. They can be little bubbles. But what they can't do is escape the big bubble.
Right.
You know what I mean?
Yeah.
They can have their own rules. They can overlap with some of the little bubbles where states have similar rules and stuff. And there's a lot of that. But they are 50 sets of rules.
Yes.
Because it's governed by the state. Now, trying to remember why I got off on that tangent, but
Well,
yeah.
our federal income tax and it's the fees that are there, or some of that goes to this program.
yeah, and they go to the Medicaid program and they offer that money to the states. So if you've already paid for it, and all these things I tell you about, these Medicaid compliant annuities, we talked about that, ourselves. The way we can assign the house so it's not subject to estate recovery. All these things. It's not what we call first stand Pierchoski 14. There's not some scripture somewhere where I'm saying this. Okay,
Right.
This is the act. These are the tools that are available to us under the TennCare Act. I don't make your stuff up.
Right.
I exercise what's in the act, and these are the options I'm telling people that you don't know about. You've never heard about these options. You just said it just now.
Yeah.
I never thought of it that way.
Yeah.
These, can you take your money and put it in, and if I have a spouse, can I change it from accountable asset, is money in the bank?
Yeah.
Let's say it's a lot. Let's say it's $500,000.
Yeah.
I'll tell you what. Let's use a real example: $485,000.
Yeah.
Money in the bank.
Yeah.
And Dad goes into the nursing home, but he still has a wife that's living at the home. Okay?
Right.
What can we take that? If we don't do anything, that's accountable asset.
Right.
It is available for the cost of care. We are expected to use that to pay.
Yeah.
But is there a way we could make it a non-countable asset and not use it for the cost of care?
Right.
The answer is yes. And where does that answer lie? In the TennCare Act, and in the Deficit Reduction Act, and in the Catastrophic Illness Act. All these things that have happened since the original Medicaid Act that supplement. It says you can do this, but here's how you have to, here's the rules on what you got to do.
Right.
You can take that $485,000. You can buy a spousal annuity, or what they call Medicaid compliant spousal annuity.
Right.
Okay. So what you're going to do is you're going to turn this $485,000, countable $485,000, into a non-countable stream of income.
Yeah.
By purchasing this annuity. Now, when you buy the annuity, you just can't go to New York Life or someplace and get an annuity. You have to get a Medicaid compliant annuity. So what's that mean? Okay, we'll let you do that, because when you do that, now it pays all to your spouse, and they get it all. It just pays over a certain length of time.
Right.
It all comes back to you've saved 100% of it, plus the interest it generates while they're hanging on to it.
Yeah.
Okay. Now this comes right from the Act. I'm not making this up. This isn't some sort of backdoor or loophole that I'm trying to take advantage of. This is what you're supposed to do with your assets. But they're not in the business of telling you what you're supposed to do with it. You got to find somebody like me that can explain it to you. You take this asset, and it's got to be Medicaid compliant. Well, what does that mean? Well, it means it has to be actuarially sound. Actuarially sound, if you don't ever heard the term actuarial, it's like, they have these charts called actuarial tables.
Yes.
And they'll go to me and they'll look under the male column and go down to my age. And there's a number there. It's how long I'm supposed to live.
Right.
Now, you're not going to drop dead that day, but it's a statistical of how long I'm expected to live.
The statistics.
So that's the actuarial tables. And so if you make an annuity, it cannot be longer than so if you're 97 years old, I happen to know the number for that. If you're 97 years old and the actuarial table says you're going to live for 32 months.
Yeah.
I know that because we just did a case with that.
Just did one.
We did an annuity, and it cannot exceed your actuarial lifetime. So you can't be 95, 98 years old and have a 40-year annuity. Okay?
No.
So you can't exceed that. That's usually never a problem. It has to be equal payments every month. You can't have $10 a month and have a balloon payment at the end or something like
Right.
It's got to be that. It has to be irrevocable and unassignable, which means once you do it, you can't ever undo it. And the reason they want that's very common in TennCare requirements, because TennCare is always worried somehow you're going to get your hands on the money while you're still alive.
Yeah.
So, here's what they're worried about on the annuity. Buy the annuity. Here's $485,000 to buy the annuity.
Yeah.
But then TennCare says, okay, you don't have $485,000 of countable assets anymore. Now you're eligible.
Right.
And they start paying.
Right.
Well, now that you're eligible and they start paying, now you go and say, hey, I want to revoke that annuity. Give me back that give me back what's left in that.
Right.
$475,000. Give that back to me. I want to.
Right.
Or I want to sign it to my kid.
Yes.
Something like that. That's what they don't let you do, because then you've thwarted the system, right? I mean, if you do that, they'll let you do it as long as you satisfy the Medicaid compliant, and it's got to be irrevocable and unassignable. They're worried about that if you can show that money will never come back to you, the applicant, then they're okay with it. And when you do that, it can never come back to you, the applicant. Now, it's all going to your spouse, so you're saving it, because if you're the guy in care, you can't own very much stuff, or they won't.
Right.
You have to pay. So you have to strip yourself of everything, but the next best place to put it is with the family. And if you're married, the next best place is with the spouse. Okay.
Right.
So I had this. I said these were actual numbers. Had this case, husband and wife husband in nursing home, wife not, $485,000 in the bank, 100% countable. With a stroke of a pen, we bought an annuity. And when you have, and this was, we can make these annuities very short or pretty long. The long is capped at the actuarial end, right?
Right.
So if it's a 10-year life period, that's as long as we can make it. But we can make them as short as 4 months.
Right.
And so, I had one that was paying, and we govern that on two things. One, the health of the healthy spouse, the one not in care. If their health is great, we'll stretch it out a while because then it's less of an income impact, right?
Right.
But if they're not healthy, we want to speed it up, okay? Get it all to her. Now that we take a little more of an income hit, but we get the money out of the annuity as fast as we can.
Interesting.
So there's ways to decide how long it's going to be. But that case, I think we did it for about 2 years. So it paid back. It paid her like $17,000 a month. Okay.
Oh wow.
For a 2-year period or whatever it worked out to be. It was a lot, and we got it all back and even earned something like $5,000 or $6,000 over that short period of time in interest.
Yeah.
And so every penny of it was saved. Now, someone says, well, you're just trying to dodge paying the nursing home. Am I? I mean, I will show you in the TennCare Act where it says, in the Deficit Reduction Act that we adopted in 2006, exactly where it says to do that.
Yeah.
And it says you can do that if you do this. If you pay it to the spouse and make it Medicaid compliant, and there's a whole list of Medicaid compliance issues. And as long as you do that, we're okay with it. And when I submit the application for that person, they say, hey, we asked for a year's worth of bank accounts, and I see what happened to $485,000. We see a complete withdrawal of that, $485,000. What happened to that? It's like, well, let me tell you, we bought this annuity with this company, Elko. It was Medicaid compliant because it's this, and this, and that. You know what the response is? If they even ask,
Right.
the response is, can we see the annuity contract? Certainly. Send it to them where it shows here's the guy's life expectancy.
Right.
It's way less than that. It's irrevocable and unassignable. Can't do anything with it.
Right.
Equal payments. I mean, all the Medicaid compliance stuff. When they see that, they say, okay, that's right. That's the way it works.
Yeah. Good deal.
And am I dodging paying the nursing home? If I was, who'd be the first person jumping down my throat or up my,
Yeah.
would be TennCare.
Yeah.
Okay, because they're the ones that have to pay the bill.
Right.
And they look at what I've done and they say, okay, we'll pick up the tabs on that person now.
Yeah.
Because we've complied with the act. No, nothing I do is some creative beat the system thing that Stan Pierchoski's thought of.
No.
I play in their sandbox.
Yeah.
And I stay in their sandbox and I use their rules. The problem is their rules are pretty lucrative. I mean, we can do a lot with their rules.
Yeah.
And, 10 years ago, we could do more. Or more than 10 years, before the Deficit Reduction Act. I wasn't even in estate planning then, but as I look back, there were even more things we could do. They kind of tightened the knot a little bit in 2006. But there's still plenty of options to do.
Yeah.
We do them all the time.
Yeah.
And so don't feel like, it's all for naught. If Ann Gertrude's in a nursing home, they're going to get everything. There's just nothing you can do. We're just SOL. It is not that way. And so we talk about that at the seminar because if that's what you think, then you're boxed in a corner. You feel like you have no options.
Right.
So what happens when you find out you do have options? You
take
might want to
advantage of
exercise
them.
one of them. And again, you're not doing anything. It's like, well, that attorney's just thinking up stuff, or he's got a loophole he's working.
Right.
I don't do loopholes. I mean, a loophole is not a legal thing. It's a loophole at best is just an unanswered question.
Right.
And if you're using a loophole to your advantage and to TennCare's disadvantage, typically the statute will be construed in favor of whom it was designed to benefit, which is the benefit system,
Right.
the TennCare. So if they ever do answer that question, you're probably going to be on their
That's a
wrong
term
end of
we
that
hear a lot, using a loophole, this, that, and the other. More than likely, most of the time you hear that said, it wasn't really a loophole. They were just using what was there to do what was legal, or they couldn't do it.
Yep. Here's a loophole. I guess you could call this a loophole, but they know all about it, and they've decided not to change it.
Yeah.
When we do these Medicaid-compliant annuities, whether they're spousal or for single people,
Yeah.
like we did one similar for your father-in-law with a single person. Now, they have to be actuarially sound, right? And it's specific, and this statute says they're actuarially sound cannot exceed, now listen to the words I'm using, it cannot exceed the actuarial lifetime of the applicant. So we go to the table, and it's a table in the Social Security Act, Title 40, Title 42, and you go to the actuarial table and it has male, female, and you go down and there's age, and then you go over and then there's a number of years.
Right.
And it's usually in decimals, like 10.2 years, and then you know. So if it's 10.2 years, what the language of the statute? What is it we can't do? There's only one thing they told us we can't do.
No,
we can't have it.
that.
We can't have a 10.3 long annuity.
Right.
It capped at 10.2.
That's right.
Now, that statute is silent on how short it can be.
Yeah.
It's just silent on that. So if my surviving my healthy spouse at home is not, her health is poor, and I want to get the thing paid off to her soon because I would rather her not pass away while there's still money in the annuity.
Right.
And I want to give it to her over a 1 year period. So, you know, everybody looks through and talk to the doctors. Oh yeah, you know, she's not going to happen in a year, that unforeseen, but 5 years probably not.
Right.
Well, we can make it 12 months.
Yeah.
And give it all to them back in 12 months because the statute's silent on that. And they know about that. That's even brought up, and the legislature decided not to address that.
Yeah.
So it's kind of a loophole because I'm saying, hey, I'm reading the letter of the law, and it says I can't go over the 10.2 years for the actuarial lifetime, right?
Right.
Well, if you're silent on how short it can be, it doesn't say it has to be 10.2. It says it can't be more than 10.2.
Right, exactly.
You got to read it like a lawyer.
Yeah.
It says what it says, no more, no less.
That's right.
It says can't exceed that number. Okay. Is 1 year exceeding 10 years? No, it's
Right.
not. Okay, so I'm good, right?
Right.
But they're not come back and say, well, that's too short. You know,
Yeah.
you have to do. They didn't say the actuarial lifetime. They said don't exceed it. Now that's been known for them for decades, really, and they in all states I think are pretty much like that. I don't know of any states that have a lower limit. on it.
I'm sure there's a purpose behind leaving it that way.
Well,
which
it
is-
gives us something.
Sure.
It gives us an option to do.
And the people who create those laws, they have families to take care of too.
Golly, I'm gonna have to wrap it up because
You are.
I'm looking at the clock and it's like, you get me all fired up. Now I need another hour.
Got you all fired up. You know,
I don't think Brian Kilmeade will let me take his
Let's
hour.
remind people of two things: the seminar tomorrow, and of course, how to contact you at your office.
Yeah, the seminar is tomorrow. Will's Trust in the nursing home. It's right here at WLX.
That's
in
right.
the back of the building at 10 o'clock. Doors probably open around 9:30, maybe 20 till or something. A lot of people get here early, but you know we'll probably open them early because it's going to be cold in the morning. But anyway,
Right.
just you know, it's tomorrow. So if you want to come and you have an RSVP, don't worry about it. Just show up.
That's right.
We'll put out more tables and chairs. We got room. It's called, like I said, right at 10 o'clock. You'll love it. If you haven't been to one, I think you'll enjoy it very
I think
much.
you will too.
LB came to one. I know, not Jeff. Mark. Mark came to
brother.
one, and
Yeah.
Mark had a good friend that came to one, and he called him later that day and said, I went to that seminar. I just couldn't believe the amount of information that came out of that guy.
Fantastic.
So I think you'll really enjoy it. No pressure. Don't worry about it. If you want to call me and talk about anything, call me at Pierchoski Estate Law, Pierchoski Elder Law. That number is 931-363-7222. My office is actually on the square in Pulaski, but that's just because you have to have an office somewhere, right?
That's right.
We deal all over the state of Tennessee. And or you can go to my website, Estate Plan Stand, and that's ESTATE, planstand.com. And there you can see my calendar. You can see that the next one after this is March the 22nd, which is a Saturday. That one's going to be at the American Legion in Pulaski, but that's 2 months out.
Yeah.
And you can get my phone number if you want to call me with a question, or you can my email. You can ask me a question by email. People do. I will answer your question. It may not be immediate, but I will answer them.
Yeah.
The girls make sure I answer all questions, either phone or email, and they print them out and give them to me. And sometimes it'll be late in the day, or even when I'm home, I'll think, I'm going to answer that question.
Yeah.
Just
Stan, good to see you again. Good to have you again. Glad to be back in the saddle.
Yeah.
And Estate Plan Stan, everybody. Again, that office is on the square in Pulaski, right there next to the Star Theater. Not hard to find at all. And you got the theaters coming up, something else there too, isn't there?
Finding Nemo Kids
Finding
is
Nemo Kids.
in production. I'll talk about that one of these
Yeah,
Fridays.
well, good deal. Good
All
deal.
right, we'll see you next
Thank
Friday
you, man.
for Bulletproof Estate Planning.
Broadcast services of Prospect Communications.
President Trump is on his way to North Carolina. I'm Anthony, Fox News.
We're going to get it fixed up. Should have been done months ago from the hurricane that took place almost 4